Yeah, this is fine. This is
Yeah?
good.
Okay.
Yeah, they shut that light off.
Yeah, see, that was the floodlight, yeah.
Yeah, okay. So you can talk there or talk without the microphone. Yeah. We can get started, okay?
No, yeah, I'll
All right, cool.
about 45 minutes, okay. All right, good afternoon. If you guys in the back perhaps find a seat, there's still plenty of seats throughout the auditorium. Don't be afraid to be close, right? So please do find seats. My name is Werner Steger, and I'm the department head of the Department of History, Government and Economics, as well as the Richard Raitano Endowed Chair in the Social Sciences here at Dutchess Community College. It is my pleasure to welcome students, faculty, professional staff, as well as interested members of our local community to our annual Constitutional Day lecture. I'd like to extend a special welcome to Dr. Pamela Edington, President of Dutchess Community College. I believe it is her first Constitutional Day lecture. Yeah, it's right here. It's okay, you can raise your hand, that's all right. And Vice President Dr. Ellen Gambino, who sits right next to her. She can also raise her hand. Okay, welcome. Welcome. A special thanks, I don't think she's in the audience though, but a special thanks to Judy Stokes, our communications director, for arranging Professor Finkelman's op-ed piece in the Poughkeepsie Journal on Sunday, and I believe many of you have read that. And also I want to thank her for working with me on this event and mostly for being patient with me as it turned out. A note regarding the logistics of this event: Professor Finkelman's lecture will be followed by a brief question and answer period. So please, when he stops his lecture, don't jump up and run out. Okay, there's going to be a very interesting, Q&A period. And after the event, everybody is invited to a reception with light refreshments in Dutchess 101, and that's just out the door, down the stairs, and there's the room. There's a reception there. To the students, you're invited. If you have a 2 o'clock class, don't skip class, right? But if you don't have class, you're invited to come to the reception. Now, Constitution Day became an official holiday in 2004 when, with the help of support from Senator Robert Byrd, the Constitution Day amendment to the Omnibus Spending Bill passed. In May 2005, the United States Department of Education backed the law when it announced that it would apply to any school receiving public funding of any kind. When Senator Robert Byrd added the Constitution Day amendment to the Omnibus Bill, he did so with the then recently passed Patriot Act in mind, lamenting in his speech that if members of Congress had had a proper understanding of the Constitution, quote, we would not have to question aspects of the Patriot Act that might threaten privacy and due process rights of Americans, end of quote. So the mandate to observe Constitution Day at all public institutions of higher learning in our country came out of a pressing concern that only a proper understanding of the Constitution can safeguard our liberties and rights. Today, the issue of birthright citizenship has emerged as another hot-button political issue, and I believe it's appropriate that today's lecture deals with the long shadow of the 14th Amendment and its impact on our country's history, delivered by one of the nation's most preeminent constitutional historians. Professor Paul Finkelman is Distinguished Professor Emeritus at Albany Law School and a senior fellow at the University of Pennsylvania. He specializes in the history of American jurisprudence and has published more than 30 books, including Defending Slavery, Pro-Slavery Thought in the Old South, Slavery and the Founders, Race and Liberty in the Age of Jackson, and most recently, A March of Liberty from 1898 to the present. That's the second half of a constitutional history of the United States. Apart from the more than 130 articles published in scholarly journals, his work could also be found in the New York Times, the Washington Post. He's blogging for the Huffington Post, and as of 2 days ago in the Poughkeepsie Journal. Professor Finkelman has also been an expert witness in a series of high-profile legal cases, such as the Alabama Ten Commandments monument case, and my personal favorite, the suit over who owned Barry Bonds' 73rd home run ball. For those of you, Barry Bonds was a famous baseball player. So, please join me in welcoming Professor Paul Finkelman to campus, and we are ready to go. Okay.
Yeah. Thank you. I'll tell you about it later. Thank you very much.
Cell phones. Turn off your cell phones, please. Forgot. Okay.
Can you hear me okay? Okay, well, thank you very much, Professor Steger, and I'm honored that President Eddington is here. It's unusual to come to a campus and find the president can scratch out a few moments of their busy schedule to hear my lecture, and I greatly appreciate this. A few months ago, Professor Steger called me, and he introduced himself on the phone and said, are you still interested in the Constitution? And I said, yes. And he said, and do you support the Constitution? And I said, yes. I was thinking, maybe the ghost of Joe McCarthy had, come up here in Dutchess County. And then he asked me, do I support all the Constitution? And I said, yes. He said, do you believe in the Bill of Rights? And I said, yes. And he said, do you believe in the First Amendment? And I said, yes, I do. He says, do you believe in freedom of religion? And I said, yes. He says, what about free speech? I said, I believe in free speech. And he said, would you like to come to Poughkeepsie and give one? And so here we are. What I'd like to talk about today, of course, is the relationship between the Constitution and citizenship. Quite frankly, in my whole career as an academic, I never would have imagined giving such a lecture because the Constitution seems pretty clear. The 14th Amendment says all persons, not some persons, all persons born in the United States are citizens of the United States, with one minor exception, which I will talk about in a minute. And so this is not something that most scholars have thought very much about. There are very few law review articles on the subject. There are various articles on what it means to be a natural-born citizen, because the Constitution requires that to be the President of the United States, you have to be a natural-born citizen. And the framers of the Constitution never bothered to tell us what exactly that meant. There are numbers of ways which you could try to understand the language. You could, for example, argue that if you were born by cesarean section, you are not a natural-born citizen. But I don't think they probably meant that. And so that has raised some questions. For example, some of you may not know this, but John McCain was not born in the United States. And when he was born in Panama, he was not a citizen at birth. Under federal law, you had to be actually born in the United States to be a citizen of the United States at birth. A year after John McCain was born, the Congress passed a law saying that the children of military personnel who are stationed outside the United States, specifically saying Panama and the Canal Zone, are citizens at birth. So John McCain actually became a citizen at birth a year after he was born. I find that interesting only because it raises the question of why supporters of John McCain and opponents of President Obama have been so obsessed as to where Barack Obama was born. Because we do know that Barack Obama was born in Hawaii. We know that Hawaii was a state when he was born. We know that he was born in a hospital in Honolulu. We know that there is a birth announcement in the local paper. But nevertheless, at least a few politicians, including the current top of the pack within the Republican presidential wannabes, Donald Trump, believes that Barack Obama was not born in the United States. Again, I always find it fascinating to see the dichotomy between what you know and what you believe. Because what you know would be based on empirical evidence, data, truth, things that we could prove. What you believe is kind of what you feel. When confronted with, say, President Obama's birth certificate, people say, well, I still believe he was born somewhere else. I don't know how we compute that, and so I don't try. But in any ways, the problem of being a natural-born citizen under the original Constitution was very simple. You were born in the United States, you were a natural-born citizen. And by the way, again, up through the modern period, if you were born outside the United States, and even though your parents were U.S. citizens, you were not a U.S. citizen at birth. And you actually had to come back to the United States and go through what is called a naturalization process. That is, you had to file paperwork to prove that you could be a citizen of the United States. You didn't have to take a test. You didn't have to have a very long residency requirement, but you did have to prove that you were a U.S. citizen. And at various times, in fact, in order to get that citizenship, you had to live as long as 5 years continuously in the United States. So citizenship in this country has always been tied to the physical place that you were born in. And so when we listen to Mr. Trump or Ted Cruz or others talk about the problem of citizenship in the United States, we have to understand that either they have not read the Constitution, they do not understand the Constitution, their lawyers have not explained the language to them, or when faced with the facts of the Constitution, they choose to believe something else. And so Mr. Trump has suggested, for example, that not only should the United States expel all undocumented aliens, but that the United States should expel their American-born children. Now, there is no federal law, there has never been a federal law that allows you, short of a trial and a conviction occasionally for certain crimes, to be expelled from the United States. And in fact, there is no law today on the books that allows any American citizen who was born in the United States to be expelled. If you are a naturalized citizen, you could lose your citizenship. So for example, if you lied on your naturalization papers, then you could lose your citizenship. An example of that was a few years ago, somebody who had been a concentration camp and death camp guard in Auschwitz was discovered to have become a naturalized citizen, and he lost his citizenship because he lied about his Nazi war criminal past on his citizenship papers. So if you're naturalized, you can have your citizenship taken away from you, but if you were born in the United States, you cannot be expelled. You could be executed for treason, but you can't be expelled. And that's because citizenship comes with birth. And let me explain how we got there, because that's what's really important. As I noted, the original Constitution never tells you how to define citizenship. It simply says that the president must be a natural-born citizen of the United States or a citizen at the time that the United States was created. In 1790, some people argued that citizenship was based on allegiance. That is, whether you sort of supported the United States rather than being based on where you were born. In the 1890s, there is a debate on the floor of the House of Representatives involving a man who was born in the colony of South Carolina, and before the Revolution, his parents sent him to England to go to school, and he remained in England going to school and going to college throughout the American Revolution. And after the American Revolution, he came back to the United States and said, well, I'm home. And some people challenged his right to be a citizen, saying that he wasn't here during the Revolution, he wasn't part of the Revolution, and therefore he's not a citizen. And the Congress, led by Madison, concluded no. He was born in colonial South Carolina, therefore he was a citizen of South Carolina at birth. And when South Carolina became part of the new United States, his citizenship transferred over. In the 1840s, there was even a more interesting case. A young girl named Julia Lynch was born in what is in Westchester County in New York, while her parents were visiting the United States from Ireland. Parents had been here for about 4 or 5 years. Her father set up a business. Julia was born, and then they took little tiny baby Julia back to Ireland, and she grew up. And she spends the rest of her life growing up in Ireland until she is in her mid-20s, at which time she comes back to the United States and claims to be an American citizen. And people argue, well, how can she be an American citizen, except for about the first 2 weeks of her life, she's never lived here. And the highest court in New York declares, well, she's an American citizen because she was born here. And that's all she had to do. It doesn't matter where she was raised. It doesn't matter where she went to school. What matters is that you are born in the United States, and that makes you a citizen. And the rule for this is based on a long-standing legal rule known as jus soli, which is Latin for the right of the soil. Jus meaning the right, soli meaning soil. And basically what this rule has always said is you are a citizen of the place where you are born, with a couple of little exceptions, which I'll talk about in a minute, because when you are born, you immediately owe allegiance to the sovereign of the place where you're born. And there are cases in England going back to the medieval period that a merchant visiting England, his wife has a child, that child owes allegiance to the King of England, that child owes allegiance to England, that child is a citizen of England. And this was the general rule accepted by every American court that ever heard such a case, by Congress, by every state legislature. It was always the same. Birth means citizenship. And by the way, the corollary, as I said earlier, was also true. If you had 2 American citizens who were parents who were American citizens, and you were born in Canada, you are not an American citizen at birth, although under federal law, you have a right to come back and claim, or in legal terminology, perfect your American citizenship. So you're not a citizen until you get back here, but when you get back here and stay for a certain number of years, then you can claim American citizenship. By the way, there is at least some question, and we can talk about this in a little bit, whether Ted Cruz is a natural-born citizen in the United States, because he was born in Canada, and his father was a citizen of Cuba when he was born. And so the question becomes, can you be a natural-born citizen, that is, and eligible for president, if you were born outside the United States and one of your parents is not an American citizen? No one is quite certain of this. What we do know, and I found this to be astounding, that in 2014, Senator Cruz, a United States senator, formally renounced his Canadian citizenship. So here the great state of Texas, the sovereign state of Texas as they like to call themselves, the state of Texas elected a Canadian citizen to be a U.S. senator. It's a little weird. And one suspects that Ted Cruz only renounced his Canadian citizenship when he realized he was thinking of running for president, and it might not look good for somebody who's a citizen of Canada, somebody who owes allegiance to the Queen of England, to try to be elected president of the United States. Now, it is also always possible, of course, to have dual citizenship, which is what Ted Cruz had. But that, again, indicates the power of the jus soli notion, that you are the citizen based on where it is that you were born. Now, the complication for this first arises in 1857, when the Supreme Court decides the Dred Scott case. Dred Scott had been a slave living in Missouri, and Dred Scott had been taken by his owner to what was then called the Wisconsin Territory, and is today known as the state of Minnesota, the home state of your president. I wanted to bring this in so she'd feel at home here in upstate New York. And Dred Scott had lived at Fort Snelling which was a U.S. Army fort in what is today St. Paul. And then he's brought back to Missouri. Under federal law, under something called the Missouri Compromise, or the Compromise of 1820, it's called both, all of that part of the federal lands was free. That is, the Missouri Compromise said there would be no slavery north of the northern boundary of Missouri. Since the Minnesota Territory was north of Minnesota, it was free. And so Dred Scott said, I became free because I was brought to a free jurisdiction. And he sues his owner, who claims him as a slave. For a variety of technical reasons, which I won't get into, he is allowed to sue his owner in federal court on the grounds that Dred Scott is a citizen of Missouri suing a citizen of another state because his owner, John Sanford, happens to live in New York. And you might ask, well, how can a New Yorker own slaves? And the answer is, you can own lots of things as long as you don't bring them to places where it's not legal to own them. For example, I don't want to give anybody any bad ideas here, but you could drive to Colorado, for example, and buy certain plant substances and rent a safe deposit box and put it in a safe deposit box in a bank in Colorado and then come back to New York. You could own that substance in Colorado. You just can't bring it here and continue to go to college and lots of other things. And you know, that's kind of an example of how you can own something somewhere else that you can't actually own where you live. So John Sanford owns Dred Scott, but John Sanford happens to live in New York City at the time. So Dred Scott sues John Sanford in federal court saying, I am a citizen of Missouri. I am suing a citizen of New York. The Chief Justice of the United States, Roger B. Taney, rules that Dred Scott cannot sue in federal court because Dred Scott cannot be a citizen of Missouri, or more importantly, he cannot be a citizen of the United States because black people may not be citizens of the United States. And Chief Justice Taney says that only whites may be citizens of the United States. And Taney gives this long history about the oppression of African Americans, about slavery, about how at the time of the Constitution, blacks had no rights that whites needed to respect, and therefore blacks couldn't be citizens. There are a lot of problems with this opinion. One of the biggest problems is that in 1787, when the Constitution is being ratified, free black men could vote in 6 states in the United States on the same basis as white men, including New York. So when New York ratified its Constitution, there were blacks who were voting for delegates to the ratification convention. It's hard to figure out how you could vote for the ratification of the Constitution and not be a citizen of the country whose Constitution you're ratifying. At the time that Dred Scott decision is decided, free black men can vote in 6 states. By the way, they're not the same as the first 6 because some states have taken the vote away from blacks, but other states have given the vote to blacks. So there's a little bit of change in the state names. And furthermore, by 1857, free black men had held public office in some states. There had been a member of the Vermont legislature who was a black. There had been elected or appointed public officials in Massachusetts, in New Hampshire, in New York. By 1860, there had been elected officials in Rhode Island. So it's very weird to think that you could be a voter and you could be a public office holder, that you could vote for the President of the United States, you could vote for members of Congress, but you're not a citizen of the United States. Chief Justice Taney recognized this non-citizenship, but said the states are free to do whatever they want. Now, this also raises some interesting questions for the modern world. Because one of the complaints of people like Mr. Trump is that there are aliens who are voting in American elections. By the way, we have almost no evidence of this. Again, this is kind of one of the things that people want to believe, but nobody's found any hard evidence. But interestingly, under the Dred Scott decision, Chief Justice Taney says black people can vote even though they're not citizens. So we have a precedent that suggests that if aliens are voting in the United States, maybe that's okay. By the way, in the 1880s and 1890s, immigrants who had not yet become naturalized citizens were allowed to vote in a number of states. So that in Illinois, in Indiana, in Ohio, I believe in Minnesota, immigrant aliens who were going to become citizens but not yet citizens were allowed to vote. So voting has not always been directly connected to citizenship. It's a separate kind of right. If you think about it, the basis of the American Revolution was the slogan, "Taxation without representation is tyranny." So if you can't vote for your representative government, maybe you shouldn't have to pay taxes. So that was part of the theory of why immigrants could vote. In any event, Dred Scott says blacks cannot be citizens. And whether we think it's a weird decision or an uncomfortable decision, it is the law of the land in 1860. In 1860, President Lincoln is elected. He takes office in 1861. As we know, immediately after he takes office, actually immediately after he's elected, a number of states leave the Union. The Civil War takes place. The Civil War may have been initially fought on the side of the United States on preserving a Union, but by 1862, the Civil War has become a war against slavery, and one of the results of the Civil War is the absolute end of all slavery in the United States with the Emancipation Proclamation and then the 13th Amendment. Following the Civil War, the question arises, well, what do we now do with approximately 4 million former slaves? Under Dred Scott, they are not citizens. Can you have a democracy in which a large percentage of the people are not allowed to participate in government? South Carolina and Mississippi are more than 50% black. So if more than 50% of the people in 2 states can't vote, can't be considered citizens, then what kind of democracy do you have? And the answer to that is that in 1866, Congress passes a statute declaring that African Americans, all people born in the United States, are citizens of the United States. And then in 1866, Congress also passes the 14th Amendment, which is ratified in 1868. And I will read you the first section of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Thus, since 1868, all persons born in the United States are citizens of the United States unless they are not subject to the jurisdiction. Now, one of the curiosities, of course, is what does it mean, subject to the jurisdiction? Again, I suspect if I could conjure up the Donald, and he kind of appeared here with full hair, and I would ask him, how can you say that somebody born in the United States is not subject to the jurisdiction? He would say, well, because their parents are undocumented aliens, and therefore their parents can't legally be here, and therefore they are not subject to our jurisdiction. And so my next question would be, well, if an undocumented alien commits a burglary, do we have a right to put the person in jail? And I suspect Mr. Trump would say, well, of course you should. And if an undocumented alien commits a murder, should the person be executed? Well, of course you should. And I'd say, then it seems to me you believe we have jurisdiction over these people. Because if the ambassador from England commits a crime, we can't try that person. All we can do is send that person back to England. Because in fact, in 1868 and in 1866, and throughout American history, the phrase subject to their jurisdiction meant diplomats. Diplomats are not subject to the jurisdiction of the United States. Diplomats cannot be jailed in the United States. Diplomats cannot be arrested. The only thing we can do with a diplomat who commits a crime is to call up the embassy and say, we are revoking this person's diplomatic privileges and putting this person on the next plane back home. Nothing else we can do. There's a really funny story from the 1960s. There was a guy who was in the British embassy who was a spy for the Soviet Union. He worked his way all the way up to the top of the British embassy. He had a diplomatic passport. and he needed to get back to England to talk to his Soviet handler in England. He needed to have a sit-down with his handler. Well, he couldn't very well go to the ambassador from England and say, hey, I need to go back home for a couple of days. Can I have a couple of days vacation? And he was trying to figure out, how can I get home to talk to my Soviet guy? And what he did was to get in his car, drive out of Washington, D.C., and drive around Virginia at 80 miles an hour, get a speeding ticket, then immediately drive and get another speeding ticket, then get another speeding ticket. When he racked up about 4 speeding tickets in one day, the Virginia government called up the British Embassy and said, you know, you got a diplomat who's got 4 speeding tickets today. What are you going to do about it? And the ambassador said, young man, you're going back to London. So he got back to continue his spying, because you couldn't try him in the United States because he had diplomatic immunity. And so the point is that the clause, subject to their jurisdiction, only applies to people who are in effect under the jurisdiction of some other country, which would be diplomats. Now, there is one little kind of footnote to this. And since we're in an institution of higher learning, we always have to have little footnotes to say that nothing is perfect. No, nothing is perfect. And that is the status of American Indians. Because in the 1880s, the Supreme Court ruled that American Indians who are born on tribal lands and therefore are citizens of their tribe are not natural-born citizens of the United States. They are not under the 14th Amendment, because what the court essentially said is, even though the Sioux Reservation is completely surrounded by the United States, even though the Cherokee Reservation is completely surrounded by the United States, if you're born on that reservation, you're born in a foreign country. You're born in the Cherokee Nation or the Sioux Nation, and therefore you are not a natural-born citizen of the United States. You are not subject to the 14th Amendment. The court also said, but of course Congress can always change this, because Congress has complete power to regulate the status of Indians. And in the Indian Citizenship Act of 1924, the Congress simply passed a law saying that, in fact, Indians born on reservations are citizens of the United States, and they have been so ever since. So the general rule of the 14th Amendment was, with the tiny exception of children of diplomats born in the country, if you are born in the United States, you are citizens of the United States. Now let me give one more piece of explanation which helps us understand this for the modern world. When the 14th Amendment was passed, there was also a Naturalization Act in place, which allowed immigrants to become naturalized citizens. The Naturalization Act said that white persons immigrating to the United States could be citizens. And that had been always interpreted to mean that people from Europe who were white could be naturalized. It meant, of course, that people from Africa who migrated to the United States, or people of African ancestry from the Caribbean or from England or from France who migrated to the United States, could not become naturalized citizens. It also was interpreted to mean that Chinese immigrants could not become naturalized citizens. When the 14th Amendment was debated, some people in Congress said we should exclude the Chinese from natural citizenship. So it should say, all persons born or naturalized in the United States, parentheses, except Chinese, shall be citizens of the United States. The Congress said, no, we're not doing that. It applies to everybody, and you may not like Chinese, too bad. If they're born here, they're citizens of the United States. So in 1868, we ratified an amendment which said that even the children of people who could never become U.S. citizens, Asians and people of African ancestry, that their children are U.S. citizens at birth if they are born in the United States. There was also a very small class of illegal aliens in the United States. There were very few immigration restrictions, so there weren't very many illegal aliens. But there was one class that everybody in Congress knew about. In 1808, Congress had banned the importation of slaves from Africa. The African slave trade came to an end. From 1808 until 1865, a small number of Africans are illegally smuggled into the United States. Probably no more than 10 to 20,000 over the period from 1808 to 1865. It's difficult to know because, of course, because they're smuggled, it's not like the census takers there, counting them as they come off the boat from being smuggled. But everybody understood that these illegally imported Africans, what today we would call these trafficked human beings, these victims of human trafficking, these people were illegally in the United States. But under the 14th Amendment, their children born in the United States were citizens at birth. So when someone like Donald Trump says there's no reason to give citizenship to people whose parents are undocumented aliens, we could say, but wait a minute. The 14th Amendment Congress, the Congress that passed the amendment, all of the states that ratified the amendment, they fully understood that children of illegal aliens, if they are born here, will be citizens of the United States at birth. In 1870, Congress changes the naturalization laws. Oh, by the way, and the other piece of this is that everybody understands that people who are ineligible to be naturalized citizens, such as African immigrants or Asian immigrants, that their children are born here and they are citizens. In 1870, we change our naturalization law to allow blacks to be citizens in the United States. So now the naturalization law says all white people and all people of African ancestry may become naturalized citizens if they are immigrants to the United States. Chinese are still left out. By the way, I'm only talking about Chinese because at this time there are no Japanese, Koreans, people from India or Pakistan, Vietnam. I mean, the only meaningful Asian community is the Chinese community. There are about 40,000 Chinese in 1860. There are probably about 100,000 by 1870 when this Naturalization Act is passed. In 1882, Congress passes something called the Chinese Exclusion Act, which dramatically reduces immigration from China to the United States. But children of Chinese immigrants born in the United States are still citizens at birth. This question reaches the Supreme Court in 1898 in a case known as United States versus Wong Kim Ark. Mr. Wong, and you should understand that in Chinese naming, the family name comes first. So if your name was John Smith in the United States, in China you would be Smith John. And so Mr. Wong was born in San Francisco. His parents were Chinese immigrants. He is raised in San Francisco. He grows up speaking California English. He is a California kid. And in 1891 or 92, he goes to China and visits his relatives and then comes home, gets to the customs, and they say, welcome home, Citizen Wong. Comes back into the United States, travels on an American passport. And then after that first trip to China, Congress passes a new law which says that if Chinese immigrants leave the country, they can never come back. So if Mr. Wong's parents go back to China, they're stuck there for eternity. They can't come back. Mr. Wong saying, hey, well, that doesn't apply to me because I'm an American citizen. I got a U.S. passport. I was born here. He goes back to China in 1895. In 94, he goes back in 1894, comes back to the U.S. in 1895, and the people in San Francisco, the customs officials, will not let him into the country. And they make two arguments. First, they say Chinese who leave the United States can't return. And Mr. Wong says, yeah, but that doesn't apply to me because I'm a citizen. That's only for Chinese immigrants. And second, the customs official says, Chinese cannot be citizens of the United States. Therefore, you lose on both counts. We're sending you back to China. Well, Mr. Wong, being a good American, understands what you do. You sue the government. All right? And so he hires a lawyer. He sues the United States. And in 1898, the Supreme Court of the United States says, in absolutely clear, unambiguous language, that the 14th Amendment says that all persons born in the United States are citizens of the United States. And they do a very long analysis of English medieval law. They do a long analysis of American law, and they finally reach the conclusion, all children, I'm quoting from the court, all children born within the dominion of the United States of foreign parents holding no diplomatic office became citizens at the time of their birth. And so Mr. Wong is a citizen, and so is everybody else who is born in the United States. The court says this is the ancient rule of citizenship by birth, and that this rule, and this is interesting, the court says that this rule is generally recognized by civilized nations. And so all the civilized nations say that if you're born here, the fundamental principle of citizenship by birth within the Dominion was reaffirmed and made explicit and comprehensive. Again, quoting from the decision. So the question is this: who's a citizen of the United States? There are three categories. The easiest one is people who are born in the United States whose parents are not diplomats. Anybody born is a citizen. The second is people who immigrate to the United States from other countries, fulfill the requirements of naturalization. They live here for a certain amount of time. They don't commit any crimes. They take a test. They pass the test. I often think, we should give the naturalization test to our students to see how many of us. I'd like to actually give the test to Donald Trump. I think it'd be really interesting what his score would be, or Ted Cruz. See if they can pass the test. They become naturalized citizens. The third category is this very peculiar special category of people who are born outside the United States, but who have one or two parents who are citizens of the United States. And the rules for them have changed dramatically over the history of the United States. So as I said, when John McCain was born on a naval base in Panama, he was not a citizen of the United States. A year after he was born, Congress passed a law saying that the children of military personnel and people working on the Panama Railroad who are born in Panama or the Canal Zone are citizens of the United States. So the Congress, in fact, in 1937, recognized that people like John McCain were not citizens of the United States at birth. And so it seems to me that had Mr. McCain been elected president, there would have been a giant constitutional crisis about whether he was a citizen. And of course, that would have meant, if he was not a citizen, that his running mate would have been president of the United States. And we would now be in the second term of President Palin. It's an interesting thing to contemplate. She is a citizen of the United States, although she could see Russia from her backyard. So in any event, that's the history of citizenship. That's where we sit. The interesting question is whether Ted Cruz, born in 1970, was a natural-born citizen. Because the rule in 1970 was that if you were born outside the United States and only one of your parents was a citizen, which is the case for Senator Cruz, that you had to come back to the United States and claim your citizenship. Now, Ted Cruz did this. There's no question. I'm not questioning his right to be in the United States. We're a big country. We have room for people of all ideas and mental abilities. Rather, what I'm questioning is, it is not clear if under the Constitution he is, quote, a natural-born citizen. Because at the time of his birth, while he had a legal right to claim that citizenship, that legal right was not based on the Constitution, but was based on a federal statute. it's up in the air. It's the kind of thing that we professors love because we can all write articles disagreeing with each other and get published, and then our deans and our university presidents are happy because we've published and we've brought fame to the place. But it is an interesting question. My suspicion is, given the polling numbers at least, that it's not going to be an issue in 2016 because it doesn't look like Mr. Cruz is going to be the Republican nominee, so we don't have to worry about it. So I want to leave it there and leave time for some questions, which I think we have. And so let me open this up to questions, if you have any. Okay, the question is, what is the current law for people who are not born in the United States and whose parents are U.S. citizens? I posed this question over the weekend to 2 law professors who do immigration law and 1 immigration lawyer and a research librarian who's very, very good. And I ended up with 4 different kinds of answers. It is very complicated. Here is what I think is the truth, having sifted through all this. Under current law, that is today going forward, if you are born in the United States of 1 or more U.S. parents, if you're born outside the United States, of 1 or more parents who are a citizen of the United States, and that parent has lived in the United States for at least 5 years prior to your birth, you are a United States citizen at birth. So, for example, if you have lived here 5 years, you go off to France for a couple of years to be a visiting professor and to study the most important thing in France, which is wine. And in the process, you have a child. That child is a citizen of the United States. I'm assuming that you've lived for U.S. for more than 5 years, so that child is a citizen of the United States. Now, it would be possible, however, to have someone who is born overseas of parents who are U.S. citizens, whose parents have not lived in the United States for 5 years, or in fact not lived in the United States at all. And let me give you the example. This is, again, the kind of theoretical thing. This is what gives students headaches, because they have to sort through all this, right? We have 2 families, American citizens. They move to France. They have a child. They each have a child, okay? They decide, we really like it in France. We're never coming home. And they never come home. And their children never come home. Now, their children are U.S. citizens because their parents lived for 5 years in the U.S., and so they are citizens of the United States. Their children continue to be citizens of the United States even though they have never been in the United States, all right? They even write back to the State Department. They even go to the State Department. You write to the State Department or go to the embassy in Paris, and they get an American passport. They meet and fall in love and get married, and they have a child. This child, the grandchild of the people who went to France in the first place, this grandchild is the child of 2 American citizens, but is not an American citizen because the child's parents have not lived in the United States. That's how complicated it gets. The other thing is, when we determine what you have to be a U.S. citizen, if you are born overseas, the determining date is not the current law, but the law at the time you were born.
So McCain, in that case, John McCain, he wouldn't benefit from a law that was stated the next year.
I think it is absolutely crystal clear that as a matter of a U.S. law, John McCain was not a citizen in the United States when he was born. and therefore he is not a natural-born citizen of the United States. And the very fact that Congress had to pass a law a year later, obviously it's not the McCain law because they didn't know little baby McCain was in Panama, but Congress, it is clear, believed that the children of American military personnel overseas were not U.S. citizens at birth. The question of Ted Cruz I have not been able to figure out because I can't, I'm not an immigration law expert. I'm a constitutional law person and a historian. And I have not been able to sort out all the immigration laws to figure out what is the law in 1970. There's a hand way in the back. Wait for the microphone, please.
Check. All right. My question is, what is dual citizenship and how can one get dual citizenship?
Okay, dual citizenship occurs when you have a legal right to be a citizen of two countries. Let me give you the example of Senator Cruz. Senator Cruz is born in Canada. Canadian law is exactly the same as American law. If you are born in Canada, you're a citizen of Canada. Senator Cruz has a Cuban father. Cuban law says if your father's a Cuban citizen, you have a right to be a Cuban citizen. Senator Cruz has a U.S. citizen mother. American law says that if you're born of a U.S. citizen in a foreign country, you are a citizen at birth. If you're, let's say that simply the 5-year residency for the parent applies. So in other words, Ted Cruz could presumably have had triple citizenship: Cuban, Canadian, and U.S. He never claims Cuban citizenship, and it's possible that Cuba won't recognize him as a citizen because his father had escaped from Cuba after Castro took over. But it's very clear that until the year 2014, Senator Cruz was both legally a citizen of Canada and of the United States. And that's dual citizenship. So you can have dual citizenship by being born in one country of parents of another country, or you can be, and that would really be the same here. So for example, if you were born in the United States, but your parents are citizens of Japan, you can claim Japanese citizenship. Or you can claim American citizenship, and I do not know what the rules are. So if you're asking me this as a personal, practical question, I do not know what the rules are in terms of claiming dual citizenship anymore, because as I said, I'm a constitutional law scholar and a historian. I do not practice immigration law. People who do that have very specialized knowledge, which I don't have. Yes, sir, there's a hand up front there. We're making the microphone guy run really hard. He's got to come up and down. That's good.
Hello. So I'm a naturalized citizen of America, but I was born in Algeria.
Okay.
And I have a passport of Algeria and a passport of America, but Algeria doesn't accept you coming to Algeria without an Algerian passport. So does that consider me dual citizenship?
I think you need to talk to your lawyer. Okay. I do not know the answer to that. And here's the other thing. It is entirely plausible that the United States would say you are not a citizen of Algeria, you are only a citizen of the United States, because when you became naturalized, you in fact took an oath to reject all foreign citizenship. And I think that's what naturalization requires. So that under US law, I'm guessing, don't hold me to this, I'm not practicing law here, I'm guessing that you are probably under US law only a citizen of the United States, but Algeria is perfectly free to say, we still recognize you as an Algerian citizen. Well, but you see, he was not a naturalized citizen. He was born a citizen because he has an American mother. So in other words, when he was born, he didn't have to take an oath saying, I reject all foreign citizenship. Naturalization is different.
We have one more question. Okay, let's do this side.
What do you think about the term anchor baby?
Oh.
What do I think about the term of anchor babies? I have two of them. One is 20 and one is 27. And both of them considered to be anchored to my frequent flyer account. Daddy, I want to go somewhere. Can I have miles? They think that they're anchored to my Hilton Honors account. Can I stay in a hotel? And they think that they are anchored indirectly to my checking account. Daddy, I need money. I think that anchor babies is a deeply stupid and deeply offensive term because it implies that people who come here choose to have children for some kind of dishonest political reason rather than they choose to have children. And again, if you watch the presidential campaign carefully, one of the presidential candidates is Governor Bobby Jindal of Louisiana. As I understand it, the definition of an anchor baby, Governor Jindal would be an anchor baby because Governor Jindal's parents were here on impermanent visas at the time he was born in the U.S. And because he was born in the U.S., they were able, as I understand it, and again, I may be factually wrong here, but I don't think so. My understanding is that they were able to convert their visas to permanent, in part because they had a child who was a U.S. citizen. And Governor Jindal joins Ted Cruz and Donald Trump in leading the charge against undocumented aliens or, in fact, immigration at all. And of course, what's curious about both Trump and Cruz and Jindal is that all three of them have parents who were born outside the United States. Trump's mother was a Scottish citizen. Jindal's parents were both from India, and Cruz's father was from Cuba. So it's a really kind of, if I were a psychologist, I could probably have a lot of fun. What is the psychological makeup of somebody who essentially says that people who are like me shouldn't be here, but I should? The other thing I have, the other question I have, and I'll just leave you with this thought. I'll leave you with it in two ways. There's a U.S. congressman from Long Island named Peter King. Peter King leads the charge against terrorism, leads the charge against undocumented aliens. Peter King is obsessed with the notion of undocumented aliens. In his earlier life, Peter King was an apologist for the Irish Republican Army blowing up buildings in Northern Ireland and in London. He apparently didn't see them as terrorists. But that fit with his political career at the moment. A few years ago, I saw but by the way, I may be mistaken that Congressman King may be from Staten Island. Does anybody know? It is Long Island. Okay, good. First guess is always best guess. Remember that on every exam. There was a news story a few years ago where they interviewed Peter King on immigration. He was going on and on and on about the problem of illegal aliens. He lives in a really nice big Long Island house. And while the interview was going on, there were a bunch of people mowing his lawn and trimming his trees. He hired some service to do this. And then they went out and interviewed all the people who were cutting his grass, and they said, "Where are you from?" "I'm from El Salvador." "I'm from Guatemala." "Don't show my face." Do you have a green card?" "I won't answer that question." And so it turned out that almost everybody who was cleaning and fixing up Mr. King's lawn was an undocumented alien. And they went back into King's house and said, you know, we want to show you this tape and we want to know, why are you hiring undocumented aliens to mow your lawn? And his answer, he got very angry. He says, I didn't hire any of those people. I hired a lawn service. I'm not responsible for who the lawn service hires. So one of the things to think about when we think about these terminologies and these debates is there a level of hypocrisy going on with certain politicians? I will leave you with this final thought. If Donald Trump were elected president, and tomorrow, the day after he's elected president, he issues an executive order to round up and deport all undocumented aliens in the United States. Let's assume that by this time he's actually read the 14th Amendment and he realizes he can't send their children away. But he says, I can, and he does. We have absolute power, if we so chose, to round up all undocumented aliens, right? We could even take green card aliens, people who are here legally, and say, we've changed the rules, you have to go home. If you are not a citizen, we can kick you out. So he kicks out every undocumented alien in the United States his first day in office. How many of you think that the dishes would be washed and the beds would be made in any of the many Trump hotels and casinos tomorrow? How many of you think that any of his properties would actually be functioning if all of the undocumented aliens were taken out of the United States? I leave you with that thought because my guess is that his whole industry would shut down tomorrow. And so you have to wonder, for a guy who brags about how many billions he's made, where is he getting the labor to make his billions? Thank you.
Okay, thank you. As I mentioned earlier, there is a reception downstairs if you have time and so inclined. Please join us.